You ain't gotta cry to me. I've been giving all my love. Tell me, do you feel it? Ever learn how to trust in the penitentiaries? Off of you, I'll take a slug, baby. You the realest. How to tell her I'm a genie. I could answer wishes. Jill, hey, that's that young boy, Genie, man. What up, man? I'm feeling good today, man. I hope y'all feeling good. I hope y'all had a good evening. Hope y'all had a good day. You know what I'm saying? Y'all blessed to be here, man. You know what I'm saying? Straight up, though. But we gonna get into it, though. Y'all know it's been a long time, so I gave y'all a Melly update, man. You know what I mean? I ain't gonna lie to y'all, man. It's been a long time. It's been a long time. So it's really not a lot of news surrounding. What's up, Tanel? Shout out to Tanel. It's really not a lot of news around the Melly case, but I mean it's a little bit, and I just was like, okay, let me give y'all a little update on what's going on and what does it mean for Melly, the families, the trial, the case for us. Because listen, those of you who've been on this channel rocking with us for a while, y'all know we definitely got a lot invested in the YNW Melly trial. And man, I ain't gonna lie to you. A lot of us, I know, because I talked to a lot of y'all, a lot of us been wanting some closure in this trial. What the fuck? Look like my light dimming a little bit now. Is my light dimming? Anyway, we've been wanting some closure in this trial. I ain't gonna tell y'all no lie. After the first trial, I was so fucking exhausted, bro. Like, and I ain't even fucking on trial, and I ain't even as emotionally invested as the family members are. You know what I'm saying? So I'm just somebody that was covering the case, and I was exhausted. So I can imagine how exhausted the people who had more emotionally invested in it than me were. You know what I mean? Like, golly. But we got a little bit of news. Well, is it good news? Is it bad news? I mean, I don't fucking know. I don't even fucking know. But we gonna break it down, and we gonna talk about it. We're gonna talk about it. That's Mickey Truth that DMing me. Her and music. They stay with the shits, y'all. If y'all let me tell y'all something. If y'all ever saw me and Mickey and music group chats, bro, I swear to God, we do this shit all day long. All day long. From fucking 7 in the morning to fucking you might get a little break between 3 a.m. and 6 a.m. By 7 a.m. in the morning again, Mickey back on. Mickey wake up like an old person. You know what I mean? She go to bed like an old person, and she wake up like an old person. But goddamn it, it's all day long. Cracking jokes, talking shit. We do this shit all day, man. But yeah, let me get into some of this content about YNW Melly. Let me see. You know what I'm gonna do? I'm gonna read first, and then we're gonna go to a couple videos and see what the bloggers got to say about YNW Melly situation. Okay, YNW Melly double murder trial on pause as prosecutors appeal judge order over evidence. God damn, shout out to, oh, Mickey was in the chat. Why y'all ain't tell me Mickey was spying on me, y'all? Why you ain't tell him they were spying on me? Boy, they say you speak of the devil and he shall appear. She is the devil, y'all. Hey, but YNW Melly double trial pause as prosecutors appeal order over evidence. Blah, 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 blah. All right. A ruling this week to suppress promotional video about Melly's life from evidence prompted prosecutors to file an appeal. Here we go again. Now, the entire case is delayed until the appeal goes through the appellate courts, which could take months. Damn. The rapper, whose real name is Jamel Demons, is on trial for the 2018, 19, 21, 22, 23 24. This man been in jail 5 years. And bruh, 5 years is a long time to be on trial for murder, y'all. Hit that like button on the way in. 5 years is a long fucking time to be on trial for murder. And of course, this trial lasted this long because it was some holdups before the first trial. Remember, they put the death penalty on the table. Then they successfully got the death penalty argued off the table. Then the death penalty went back on the table. All of that shit postponed to the shit. Now we got other postponements, and it's pretty much the same similar situation. But I'm gonna read this for you. The rapper's whose real name is Jamel Demons is on trial for the 2018 killing of two friends, Chris YW Juvie Thomas, Anthony YW Sack Chaser Williams. The first trial against Melly ended in a mistrial last summer. The motion centers on a 20-minute documentary about Melly's life and a rise to fame, which was filmed just before the double murder. The video often shows Melly holding a weapon. In the last few seconds, it mentions the deaths of Thomas and Williams. If y'all remember not, that's that video where at the end of it, it said that YW Melly and his friends were a victim of a drive-by shooting, and that was the evidence that they was using to say that Melly was on the scene of the situation. You know what I'm saying? The defense is trying to get parts of the documentary removed from evidence so the jury in his second double murder trial will never see it, saying it's hearsay, but the state says it proves Melly was on the scene. Do it prove he was on the scene? I don't know if it proves he was on the scene, but I do think it insinuates that he was on the scene. You know what I mean? Like, it don't prove he was on the scene, but it does kind of point to that he was on the scene. You know what I mean? And I can see why they want that out of there. And I can see why the state wants it in. You know what I'm saying? But what does this mean? What does this mean? Let's do a little Googling here. Let's do a little Googling. Let's see how long these processes take. Let me see if I can find the right words. How long? To the state Supreme Court. Okay, let's see. I want to know how long it take for this stuff to get appealed to the Supreme Court. And of course, argument each state is kind of okay. So it ain't that long. It say the time for filing a direct appeal to the Supreme Court is 30 to 60 days. But as we remember not, when they was going back and forth with the death penalty, that shit took a long time. I'm not sure exactly, but I'm pretty sure it took over a year. So, but they saying 30 or 60 days, and I'm assuming this going to the Florida Supreme Court. Y'all think this going all the way to the Supreme fucking Court of the United States. I think she said it varies. Mickey said it varies. The state getting the time they need, though. They are. And that's what I'm saying. Like, I wonder. I ain't gonna say because I don't want to start those conspiracies and nothing like this here, but I feel like nah, they ain't gonna. They want his head. I just feel like this case been dragged on so long to where if we get any more delays, I can see some sort of resolution coming. Like, I don't know, maybe a plea or something like that. And it's up to him. It's up to first, I got to offer him a plea, but it's also up to him whether he's going to accept a plea. But just think here. He been in jail for 5 years. I'm pretty sure there's people that's been going to trial longer than that, but I'm just saying this is highly irregular for somebody to be going to trial for this long. Shit, by the time he get convicted, he gonna be done did a third of his time. You know what I mean? God damn, hit that like button, hit that like button. Let's see what the Cuff Boys say. I think they dropped the video, and this article, it was an okay article, but I think it's more to this. I don't think this is just the end of the whole situation. I think it's something else that they appealing, and I think it's more evidence. It's something else about the evidence. Um, I don't think this is totally everything. So give me a second here. Mickey said at this point the state has no case. I'm trying to refresh my memory as to what was going on. It's been so long, y'all know, since we kind of like done tipped on this Melly case. Yeah, because a lot of the stuff got threw out. A lot of evidence that that was allowed in the first case, the judge threw it out. So I'm sure that this case is looking weaker than the first case, being that a lot of the evidence was thrown out. Let me see. Okay, here we go. Shout out to the Cuff Boys. We're gonna listen to the Cuff Boys real quick. Jit be kind of thorough with his funny hair.
One Deputy Melly murder trial was officially delayed. Prosecution has filed an appeal, which has subsequently put the trial to a complete standstill. So yeah, I haven't updated on this trial in a while because not much has been happening, but
me neither, Cuff. Me neither.
For the millionth time. This time it's because the state is trying to change shit that the judge ordered on. So I'm gonna read it and explain it to you guys the best I can understand it. It has to do with that promotional documentary that Melly put on his YouTube channel. So yeah, let's get right into this video. Subscribe. Here we go. State of Florida versus Jamel. Notice of appeal. Notice is given that the state of Florida appeals to the 4th District Court of Appeal. So it looks like there's 3 things they're appealing. The non-final order suppressing evidence as noted in the omnibus order on defense motion to suppress evidence 1 through 13. So I think they're appealing the window that the judge gave on certain pieces of evidence like the Snapchat, the phone records, all that. Because he gave a new window of time frame between 3 a.m. and like 6 a.m. or no, 3 a.m. to 9 a.m. is what he gave on some of the evidence, which shoots down a lot of what the state had. And then the second thing...
Okay, so this goes back to what Mickey was saying. See? So they appealing the window. Remember the windows that the judge gave them in order to look into certain evidence? So they're appealing the window. Because that's why I knew that article didn't have all the particulars in it. So they're appealing that window of time that the judge gave them to be able to look into Melly's electronic what do you call it? His Snapchat, his Gmail, his Facebook, his iCloud, all of that stuff. Before they were allowed to just look at everything. You know what I mean? They got the whole history of Melly's iCloud. Well, this time around, Melly's attorney successfully argued that they should not be able to look at every goddamn thing. And I agree. Like, goddamn, y'all gonna look at my whole history, my whole iCloud history? You know what I'm saying? Like, it's all kind of shit in there. You know what I mean? Goddamn it, they look at my iCloud history. Who in the fuck? Like, come on. So the judge narrowed the window, and what's going on now is that cut out some of the evidence that they was using in the first trial. You know what I mean? Because they gathered shit from every goddamn well, in his electronic communications. So the judge done narrowed it down, and the state don't like that because they know that it was some stuff that they was going to use or that was used in the first trial that they can't use in the second trial. Shout out to Anonymous One. Shout out Music 101. Okay, so that's one thing that they're appealing.
Appealing is the non-final order of this court denying the state's motion for reconsideration of the court's omnibus order on the defendant's motion to suppress evidence 1 through 13 as noted. Okay. Third, the non-final order of this court granting the defense motion in limine the promotional video. The nature of orders 1 and 2, as reflected above, are the granting of the following non-final orders noted in the omnibus order suppressing evidence, as well as the denial of a non-final order denying the state's motion for reconsideration. So to dumb this all down, it sounds like the state's salty about the judge's orders, and they're saying no, and they apparently have the power to pause this entire trial and put in an appeal, and that has to go to a higher court. The 4th DCA, partially granting defense motion to suppress.
Boy, you see that? You see what he said the state doing? So since the judge done ruled on this stuff, the state is pulling a fluke rule, shout out Music 101, and they done put this stuff in appeal, essentially pausing the trial. That goes back to what Mickey was saying. It seems like they feel that their case is being weakened and they don't want to go to trial without some of this evidence that they had in the first trial, but has been taken out of the second trial due to the window of time that they can look into Melly's electronic correspondence. So evidently, they feel, like Mickey say, they must feel like they don't have a case because they don't put the whole trial on hold. Fuck that. Bitch, we finna go to appeal because we need this evidence that you are keeping out, Your Honor. That's what the state is saying, and that's what the state is doing. They're using their power to pause this trial in order to get this shit appealed so that they could possibly get this stuff in so that their case could be stronger. It's looking good for Melly, guys.
iPhone X, iCloud account, his Snapchat, his Facebooks, his Instagram.
Hit that like button, y'all. Hold on. Hey, look, we're going to pause this thing real quick, man. Hit that like button, man. We got 50 people in it. Y'all know this is a Melly channel. This is what this channel started on. Hit that like button. Hit that like button. Hit that like button. Hit that like button. Get us up, man. Get us up. This is what I'm finna do. I'm finna pause the video for a second to give y'all a chance to get right because y'all still in out of self-checkout. Know what I'm saying? For real, for real. Shout out to Chris G. Shout out to Normal White Guy. Like that name. Shout out to Boredom and Clicks. Shout out to Anonymous One. Shout out Music 101. Shout out Just Win Baby Podcast. I like that name. Shout out to y'all, man. Shout out y'all. That's a nice name for a podcast. Shout out my girl Mickey Truth. Who else? I want to get all y'all shots out real quick. Y'all get them likes up for your boy, though, man. Y'all get them likes up for your boy. Y'all get them likes up for your boy. Please do that for me. Please, man. I would appreciate it, man. I would appreciate it. Let's go.
His emails, and then another email. So this is the time frame the judge gave, 3 a.m. on October 26, 2018 to 9 a.m. on October 26, 2018, which is basically like a 6-hour window surrounding the time frame when the murders happened. The state doesn't like this. They don't want this.
So they only got 6 hours for... Hold on. I want to know if that's the iCloud or if that's the fucking... Let me be nosy here, y'all. Give me a second here, y'all. I want to know. I got to know. I got to be correct here.
This is the time frame the judge gave, 3 a.m. on October 26, 2018 to 9 a.m. on October 26, 2018, which is basically like a 6-hour window surrounding the time frame when the murders happened. The state doesn't like this. They don't want this time frame. They want to have way more leeway on this time frame to get more evidence to make Melly look like he's guilty. Right. That's the whole point. They're trying to show the whole picture, essentially. They did this with the emails, too. And that was a big one because I believe a lot of the gang affiliation with Melly emailing gang affiliates.
It's going to be out there.
The whole rule book of the Bloods. And
all that shit out.
Being emailed to him and him, like, replying back, talking to the Blood, saying herc and shit. They can't use that now, essentially, but they're going to be able to use a lot of his Instagram and pictures of him anyway. Here's the order.
So you hear what he said? You hear what he said? So all that gang shit that happened before the murders and all of that, they ain't gonna be able to put none of that in there that came from the emails. None of that shit. None of the gang correspondence between some of these gang members and all that. That shit ain't gonna be in there because it's not in the time frame. They only got a 6-hour time frame for this specific electronic correspondence because it's different time frames for different social media outlets and electronic correspondence. When I mean electronic correspondence, I mean like emails, I mean like messages, I mean like Messenger, DMs, Snapchat, Facebook posts, all of that shit. So different ones have different time frames that the judge allowed them to the state to look in. But they all narrow. Them bitches all narrow. They all narrow way more narrow than it was in the first trial. The first trial, they just used every fucking thing. They used everything from Melly's whole history in iCloud. On this one, nah. You see the difference between attorneys. You see the difference attorneys makes because his first legal team did not get this stuff thrown out or the window, but the second one did. So you know, we was under the impression that that black guy that Melly had, he did a phenomenal job. The black guy definitely did a great job. But here we can see, and we was kind of under the impression that Melly might be making a mistake because he was the only one that got that Melly didn't allow back on the second defense team for a second trial for whatever reasons. But it does look like a good move because these new lawyers that Melly got in them, they fighting. Them motherfuckers fighting, bro, and they winning. They getting a lot of this shit thrown out. They getting a lot of this shit suppressed, all that type of shit. So when it comes down to it, Melly's chances are looking better when it comes to the evidence that they're gonna allow in or not in. You get what I'm saying? You know what I mean? Shout out to Chicks 1000, aka the Chick 1K. Let's keep going.
Defense motion eliminate promotional video. Defendant moves to prohibit at trial a specific portion of the promotional documentary video from coming into evidence. The portion at issue in this order is a 14-second portion. From 2014 through 2027 is the timestamps, where the video depicts the text 4 days after the completion of this film. YNW Melly and his friends were targeted to the drive-by shooting in Miami, Florida. YNW Juvie and Citation were killed. That portion also shows the defendant standing in the background. Defendant claims that this clip from the video is inadmissible at trial since the text included therein is hearsay and double hearsay, not attributable to defendant and irrelevant. The state claims that this clip is an adoptive admission, an exception to the hearsay rule under section blah 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 Florida statute. The court agrees with the defendant that this 14-second portion of the video is inadmissible at trial. The text displayed on the screen is not attributable to any specific person, so the judge is agreeing with what Melly is saying.
So the judge agreed. The judge agreed that that little part, if y'all go on YouTube, it's still there. The documentary, Melly's documentary about his life, is still there. That little part at the end where it says on such and such date, Melly's and his friends were victim of a drive-by shooting, YW Juvie and YW Sack Chaser were killed. That part right there, the judge agreed that that is inadmissible, and they will not be able to use that in the second trial. Now they used it in the first trial. You see that shit? They used it in the first trial. Now I gotta see this shit crazy. That just break it down. That just let you know that if you ain't got competent legal representation, you could go to jail and you could have possibly been found not guilty or charges dropped or anything. This is, dog, this shit crazy, bro. Like, this shit crazy because they got the same fucking judge. The judge let them use the shit in the beginning, in the first trial. So I got a question. Was the judge just sitting back like, damn, they could get this shit thrown out, but they ain't even asking me? You see what I'm saying? And he just sit back and let the lawyers do their thing. That's crazy.
Whoever wrote this text on the screen saying Melly was present in the car doesn't necessarily mean it was Melly typing it. Like, it could just be an editor of some kind. While this short video...
Okay, so they're saying that whoever wrote that on the documentary, that doesn't mean that Melly wrote that, which he probably didn't. They're saying that that's somebody else wrote that, which means it's hearsay. It's not an admission that he was there because he ain't say he was there. Somebody else wrote that. Hey, now I learned something.
Defense life, it is mere speculation to guess who decided to add the text statement at the 2014 mark. Could have been the director, producer, editor, defendant, or any number of people. Thus, without knowing the source of the comment, it holds no evidentiary value.
Judge agreed.
Judge is kind of snapping on this one. I mean, we all got to agree with that.
Yeah, I agree.
Really know who typed that, and I highly doubt it was Melly that typed that. I mean, you think Melly's out there editing a documentary? No. Next, this court finds the state's argument that this text statement and this clip is an adoptive admission by the defendant to be without merit. For an adoptive admission to be considered an exception to the hearsay rule, it must be a statement that is offered against a party and is a statement of which the party has a manifest adoption of belief in its truth. What does that mean? I don't know. Merely because the entirety of the video was posted on defense YouTube page does not make everything contained there on an adopted admission. Oh, so they were just saying because it's on his own YouTube page, he said it. It was him.
No.
It's on his YouTube page. He wrote it.
No.
I get it. It does pretty much say that he was in the car, and I guarantee whoever wrote that The editors regret writing that.
Yeah.
As the 4th DCA pointed out in Phillips Morris, USA, when an adverse party manifests a belief or adopts a statement as his, and the statement is treated as an adoptive omission under section of the law. An adoptive omission occurs either when there is a direct expression of an adverse party assenting to the statement of another. All these big words, dude. Like, just say, what are you saying?
Hit that like button, guys.
Idiot reading this shit sometimes, dude. In the instant matter, with regard to the text of the 2014 mark, there is certainly no direct expression by the defendant assenting to that statement. Furthermore, the act of posting this video on his YouTube site is not conduct circumstantially indicating his assent to the truth of that particular statement. Okay. The statement is neither attributable to defendant nor do the circumstances demonstrate his adoption and assent to the statement. The evidence points to nothing indicating defendant manifested an adoption or belief in the truth of the unattributed statement. Thus, the text at 2014 through 2027 remains inadmissible hearsay. Jesus. All right, so the judge ordered this on January 25th, right? At 7:30 in the morning. He did this at 7:30 in the morning, right? The appeal that I read earlier in this video was sent in at 2:16 p.m. right here. They filed this at 2:16 p.m. So they did not waste no time, bro. They put together a 50-page document within like 6 hours or so, appealing this to the 4th District Court of Appeals. Like, what the... They are not playing...
So it's going to the 4th District Court of Appeals. Okay, so... let's see how it goes. And I'm going to tell you, I'm willing to bet that if this shit finna get postponed far longer than 30 to 60 days. Let me tell you why. Or possibly. Because if the appellate court rules in the state's favor, or I'll put it this way. If the appellate court rules against the state and say that this shit is inadmissible, you know what they're going to do. They're going to appeal that shit up to the next court. And this shit gonna go up and up and up and up. So, bruh, Melly ass finna be in that bit for about another year, dog. All jokes aside, I promise you. Melly, this shit finna be on hold for a minute. Because these people at a stalemate, they are not going to trial, or they don't want to go to trial unless they can use the shit that the judge done threw out. So what they doing is they appealing the shit on up the ladder until they get a favorable verdict, or until it gets to the end to where they can't appeal it no more. This shit finna, this shit finna go on for a while, bro. This shit finna go on for a while. And what they was trying to say is that since that video was posted on Melly's YouTube channel, then that's like an admission of guilt. No, the fuck that ain't. No, the fuck that ain't. The editor and all of them is the people that edited that shit and put that shit into that video. Now, I do have a question, though. Once the murders and shit happen, why is that video still up with that shit in there? Even though the police had that shit early on, they had it early on. I'm saying, I still think I would have took that bitch down. I think I still would have. Oh, god damn it. What's going on with you? Hold on, y'all. We got technical difficulty here. Hold on. Damn. Really, dog. Technical difficulty. Hold on. Like AK-47 in there, bitch. Damn. Hold on. God damn, boy. Boy, every time I do a Melly motherfucking live, goddamn, some shit go on. Goddamn, if they ain't cutting off the live, goddamn, every time I do a Melly live, y'all notice that? Remember they used to cut off my lives and shit? Y'all remember that shit? Boy, I tell you, boy. Boy, I tell you, boy. Melly got them, the woo lady working. I swear he do. God damn, y'all know the dude that used to own Melly record label run YouTube music now. Boy, they got the roots on me, dog. Shout out to Kim Bella Roxy. Hit that like button, y'all.
It might have been a mistake getting a new prosecutor in this case. Like Alexander Bruckaloo and Harold F. Pryor do not play games, bro. Notice of cross appeal. Jamel Dimmons, defendant, cross appeals to the 4th District Court of Appeal. The non-file orders of this court. This cross appeal is limited to related issues resolved in the same order as being appealed by the state in the notice of appeal. I think what they're doing is saying, we're going to appeal what you're appealing. I think. So it looks like they list all the orders partially denying certain things. So what I think is Melly's team is going for here is they want them all to be granted. Like they're like, we don't want these to be partially denied either. We want everything else to be granted. So they're going for everything, basically. They don't want any of this evidence in the trial. The Facebook, the Instagram, the phone, the Snapchat, iCloud. They're going for the whole, they're putting their nuts on the table, boys, essentially, is what it looks like here. But that's my understanding of all of this, even though...
Melly, I told you, them motherfuckers working over there, dog. Listen, Melly defense team trying to get all this shit throughout, and they done been successful. I think if we had to score this second trial, if we had to score this bout, Melly's defense team definitely done won leading up to the second trial because they have been successful in getting a lot of this evidence thrown out, and this is why the state is appealing this stuff up to the 4th appellate court, because they don't feel like their case is strong as it was because this stuff is not being allowed in the second trial. So hey man, let's go one for the little ugly motherfuckers. Go one for Geico Lizard, man.
Using big words, and I did not go to law school. It's funny, people always like comment, like every once in a while I get a comment saying like, this kid doesn't know what the fuck he's talking about. Yeah, I read it and I analyze it from like a normal person perspective and try to like help normal people understand what the fuck is going on, because I didn't go to law school. Like obviously, I'm a ginger kid. Makes YouTube videos, bro. This is for entertainment. This is just an order by the court saying that Melly seems to pay this $295 filing fee, or else they can't appeal this shit, essentially. And that's crazy, bro. 5 years later, we're getting this. Acknowledgement of new case. 4th District Court of Appeal has received a case initiating document reflective of filing date of February 16th. How exhausting, bro. Holy shit. Respondent shall file a response within 20 days from the date of this order and shall cause why petition should not be granted. Petitioner may file a reply within 10 days of service of the response. Okay, putting them on a little time frame constraint of some kind. So this is a documentary that is in question. I
Don't play that
shit. If they showed some of it or not, or maybe it was a small clip of it to the jury. But I know it was discussed in the first trial. I remember it. Throughout this documentary, I mean, it's talking about him like being obsessed with guns and loving guns and shit. So, and he's holding like an AK-47 and like shit that probably shouldn't be shown to the jury. That's Juvie right there, who Melly allegedly, killed in their sack chaser. All throughout this documentary of them all three hanging out together, showing this to the jury is going to be very confusing. Being like, wait, what the f***? They were this close? Like, if they can hear all of what they're saying, they're like best friends, like laughing and chilling. So that's a gun laying on his bed next to him, next to his phone. Literally in a Draco.
I seen some shit shining. It was a 22 revolver, a real gun. I'm a kid though, so I just walk out the house and I shot that bitch. And I couldn't hear out my ear for like a week. And then I was like, damn, this is a real gun, you know what I'm saying? I was on that 4th grade, but I took that bitch everywhere. To school, I took that bitch everywhere.
Yeah, show that to the jury, it's over. Like, come on. He took that bitch everywhere. A gun to school in 4th grade. I mean, if they use his lyrics against him in this video, just these lyrics in video, is not a good look.
Okay, I'm gonna say this. They talk about parts of the documentary that show it was a gun there when they were shooting the documentary, and they talk about the story when Melly said he found the gun and he shot it and he took it to school and all of this stuff, and then that will not look good if the jury see that. But it's other parts of the documentary that I think will look good for him. When you listen to how close they were, when you listen to the bond that they had or seemingly had, I think it could make some jurors say, damn, I don't believe he did this. You know what I'm saying? And I do think other parts could make the jury say, or some members of the jury say, he might have did this. You see what I'm saying? So it's a slippery slope with that documentary. If it was me, I'd kick the whole documentary out. If I was his attorneys, I want the whole goddamn documentary out. I'm just saying, if I was them. And if I was the state, I want the whole motherfucking documentary in. That way we can pick out little pieces. Shout out to Brittany Baker. So we can pick out little pieces of the documentary that we want to use. But the documentary definitely will be confusing to the jury. I think it could sway them either way, and I think it could sway certain jury members this way, and I think it could sway other jury members the opposite way.
Bro. So here's the part in question right here. 4 days after
4
the
days
completion
after
of this film,
completion of
one
this
of his friends were charged with a drive-by shooting in Miami. Two exact were killed. So the state is saying that this is an adoptive admission. The judge is saying it's not an adoptive admission, and that the 4th DCA has already ruled on this before. So I see this not going in favor of the state, essentially. If the 4th DCA has ruled on this before in another case, this seems like a huge waste of time, and I feel like it could be them stalling. Like, it could be the state stalling for more time because it's 2 new prosecutors on the case or whatever, and they're trying to just have more time to collect everything and figure out how they're going to approach the trial.
Right.
That's been one of their big complaints is like, we can't start this trial this soon. We're just now getting started on this case. But yeah, comment down below what you guys think. I think this is a stalling tactic for the state, and they know they're not going to win this appeal. And yeah, hit subscribe. Love you guys.
Shout out to Cup Boys. Y'all go subscribe to the Cup Boys channel. He got like 2.1 million followers, subscribers. So hey, look, man, go jump on bruh shit. You know what I mean? Shout out to him. So what does this mean for the new Melly trial? It means you ain't gonna get no motherfucking Melly trial for a long time. So we gonna be sitting on our hands on this one for a while. I know the families probably want some closure. I know. I don't even want to speculate how Melly feel at this point. I mean, he's still fighting for his freedom, so he still got a fighting chance. He probably feel good about some of this evidence not coming in. You feel what I'm saying? He probably feel like he got a better opportunity. His lawyers, his attorneys definitely are fighting more for him and actually winning the fight in the second and leading up to the second trial. They got a lot of evidence thrown out. They got the windows narrowed to where the state can look inside his iCloud, email, social media, and a lot of the stuff that they was using in that first trial won't be, at this point, won't be able to be used in the second trial. So, score one for Melly's defense team. I mean, I really don't see any wins that the state has gotten so far. But what the state has done is they just don't put a hold on the whole trial until this stuff goes to the appellate court because they want this evidence in. They need this evidence. This evidence is essential to them putting their case on. I think what happened was the motherfuckers prepared for the second trial off the evidence that they had in the first trial. But Melly's attorneys pulled a fluke rook and they motherfucking started getting some of that old evidence kicked out. Now that made the state have to reassess, reassemble the whole case and see what evidence that they could use. And I'm assuming that once they looked at the little bit of evidence that they could use in the trial, they was like, fuck that. We ain't going to trial like this, bitch. We finna appeal this shit. You know what I'm saying? So that's what's going on here, man. I'm gonna try to keep y'all posted up on some of this stuff, man. You know, the Melly case, it ain't. What I'm gonna do is, what I'm probably gonna do is, and I said this before, but I'm for real. We just gonna have to go. But then again, being that some of this evidence is not gonna be in the second trial, I wanted to go back over the evidence that was used in the first trial, and I probably will. But but some of the evidence has been thrown out. Some of the evidence has been thrown out. So if we go back over it, it might not even be evidence that they're gonna use in the second trial. So what I'm gonna do is I'm gonna get on the Broward County Clerk of Courts and I'm gonna see what they got on Melly or what they can use or what they're using against him in the second trial. And we probably gonna go through that because I know you guys come here for the Melly content and it just ain't been no Melly content in a while. So we gonna dig some up. We gonna do like them boys from Chicago. We gonna remix the same goddamn stories of something goddamn. We gonna do something, but we gonna keep you guys fed when it comes to this Melly case because you guys definitely are invested. I'm invested. I really want a resolution to this case. I don't even know. You know what I mean? I don't even have an opinion at this point as to whether I think he's gonna get convicted or not because I don't know exactly what the state got against them now. You know what I'm saying? I know what they don't got. You know what I'm saying? Like, share, comment to this video, man. I appreciate y'all, man, for tuning in. Hit that like button. Go watch some other videos. Follow me on Instagram, MaritaBoy1, MERITABOY with the number 1. Shout out to Chicks 1000, aka the Chick 1K. Shout out to Sonia Quintanilla. Sonia Quintanilla. Shout out to Trav. Shout out to Zariah Nicole. Shout out to Chicks 1000. Who else? I can't even say your name. Bro. Baloney is fire. That's what I'm gonna say your name is. Baloney is fire. Shout out to Kimbella Roxy. That's my family right there, y'all. Y'all go subscribe to Kimbella Roxy YouTube channel too, man. Also follow on Instagram. Shout out to the second. Shout out to Michael Justice. Shout out to PRK Gorilla. Pussy. Shout out to Brandon Brown. Shout out to Day. Appreciate you, gang. Shout out to Anonymous Ones. Shout out to Mickey True. Shout out to Music 101. Shout out to Boardman Clicks. Shout out to Flyboy Michael Foles. Shout out to Nephew For Real. Shout out to Silk Foster Jr. Shout out to Deputy Eula. Shout out to Nate Said It. Shout out to Tennille Bowens. Shout out to Audio Crack 22. Shout out to all y'all, man. Like, share, comment this video.